Governor of the FCC and co-convener of the Professional Committee. Sorry, is this working all right? Good. Welcome to today's club lunch. Let me first remind everyone to switch off your mobile devices if you haven't already done so. And do take a look at our club website for the many events that are coming up in the next few weeks. I'll just mention a couple of them. March 27th, David Kaplan of the Global Investigative Journalism Network will be here to talk about how investigative journalists are reporting increasingly across borders. And then on March 31st, well-known commentator Eswar Prasad will be here to talk about the future of the renminbi. And now it is my great pleasure to introduce today's speaker. Mr. Russell Coleman SC was called to the Bar of England and Wales in 1986, and he has practiced as a barrister in Hong Kong since 1990. And he took silk in 2006 and served as chairman of the Hong Kong Bar Association's Bar Council in 2009 and 2010. Last May, the Law Reform Commission began a detailed review of the Access to Information Code in Hong Kong, and its findings could lead to important changes to government transparency. And Mr. Coleman became chairperson of the subcommittee that's undertaking the review. So really, I mean, he's the best person in town to tell us all about it. So please join me in welcoming Mr. Coleman to the FCC today.
Well, I'd like to firstly thank Enid for that introduction. There's nothing better to put you in your place just before you start a talk to be told of the rather more stellar personalities who will give talks on the next two occasions. And I'd like also to thank the club for inviting me to give this talk today. I remember the last time I gave a talk standing on this stage. It was at one of the Wig and Pen events. I don't know whether you've ever been to those. The idea is that it's a debate, loosely, between a journalist and a lawyer. I was the lawyer on the particular occasion, and I was told that the whole idea of the evening is to run down journalists, if you're the lawyer, and to try to talk up lawyers. I put some enthusiasm into my role that evening, but obviously I'm not going to make that mistake twice in this particular club. Now, the introduction suggests that I might have been selected as the chairman of the particular subcommittee of the Law Reform Commission dealing with the question of access to information because I knew something about it beforehand. But let me tell you that in the time-honored tradition, how I came to be appointed. Sensibly, it was in February of last year, I was skiing in Japan when I made the mistake of answering a phone call on my mobile somewhere near the top of the mountain because I saw that the caller was one Rimsky-Yuen. I had, of course, at altitude, forgotten that he had become the Secretary for Justice, who was no longer my next-door neighbour in Chambers. I ought to have known better. It was pointed out in the introduction that I became chairman of the bar, and it's a well-known fact that I was the chairman who succeeded Rimsky as chairman, and the only reason that I took the job was because he kept banging on our partition wall between our rooms in Chambers because he couldn't find anyone else to do it. Anyway, having taken the call, I was prepared to agree to anything that he would say in order to get him off so that I could get down on my next run. Later, when I got back to Hong Kong, he reminded me that I had agreed to be appointed to this post of chairman of the subcommittee dealing with access to information at the time that two connected committees or subcommittees were set up, the other dealing with archives law. So, we started, having set up the committee. Perhaps I should just remind you of the terms of reference. The The terms of reference signed by the Chief Justice and the Secretary for Justice are to review the current regime relating to access by the public to information held by the government or public authorities for the purposes of considering whether reform is needed, and if so, to make such recommendations for reform as appropriate. So, inherent in that term, those terms of reference, is the question, perhaps expresses the question as to whether or not any reform is needed. Our committee has been set up, which comprises different people from different backgrounds. We have academic lawyers, we have lawyers in practice, we have people representing the journalists, we have people from the civil service. And so far, since May of last year, we have met on 7 occasions. And we have broadly arranged to meet once a month, give or take a month in the summer perhaps, and perhaps sometime at Chinese New Year, on an ongoing basis with a view to reaching our view and expressing those in a report for consultation purposes first. Now, because it's a slight irony in this talk, isn't it, that I'm not actually allowed to tell you what we are talking about in the Law Reform Commission subcommittee on access to information, because I can't give you access to that information. So I'm just going to work on the basis that, notwithstanding I know some of you in the audience, that the rest of you are quite intelligent, and that you will be able to work out for yourselves what it might be, from what I say, that the committee might be expected to be doing, although I'm not going to tell you whether that's right or not. Because I didn't know much about this topic before I was put into the role, personally at least, and you might think as a committee it might be sensible also, there's a good deal of learning to be gone through, some educating about access to information generally, what the current situation is in Hong Kong, and what are the options that have been looked at internationally for dealing with this relatively thorny topic. It's a topic which has its own tensions, of course, between those who hold the information and would be providing access to it, and those, it might be said, for whom they hold that information and might want access to it. I know that the Hong Kong Journalists Association has been raising this topic on a number of times, and in a paper in July 2013, last year, headed "Dark Clouds on the Horizon, Hong Kong's Freedom of Expression Faces New Threats," there's a section dealing with the association's calls over many years for the enactment of a Freedom of Information law to replace the existing administrative code, which came into place in 1995, shortly before the end of the British colonial era and the resumption of sovereignty in 1997. Now, the system that's in place at the moment is that administrative system, and it's important, I think, for anybody considering any question of reform to understand what is the current situation and what might be the drivers for any change to that situation. And I'd rather hope that when I came here today that the Q&A session that I'm told I have to give at the end would be me asking the Qs and the audience giving the As, so that you could tell me what are the drivers for this change in Hong Kong. I'm told that there's probably only one journalist in the room. The rest are lawyers. Heaven forbid, they're even members of my own chambers who are obviously desperate to gather some dirt on me for the coup that's about to take place. I'm no doubt going to be sacked from chambers, and they're looking for material that would enable that to take place. Either that or they're really bored. And so I suppose you may have some questions from me which I will either try to answer or answer in such a way that I use lots of words and not actually tell you anything. Because I too am capable, having been chairman of the bar, of being a politician. Now, the existing policy, as I say, it's an administrative policy. The idea behind it was that it might be a way of seeing how a system of access to information in Hong Kong might run in order to consider whether any different system, new and improved, might be brought into place in the future. The idea is to make available to the public information which government departments or public bodies have. And the general approach is to work on the basis that information will be released unless there's a good reason to withhold disclosure under the second part of the code. Now, the first part sets out the information that's to be published routinely, and you'll find this, I think, in most freedom of information regimes, the idea that there should be the routine publication of certain types of information. Shouldn't have to ask for it. It should be there routinely. And the first part of the code also then lays down procedures governing prompt release of information that's sought, some kind of internal review process, and a complaint system as regards the ombudsman in Hong Kong. And I might digress at this point to identify, as many of you may know, that the Ombudsman is compiling a report in relation to freedom of information or access to information in Hong Kong. And although the report publication date has not been stated, I think it is understood that the report might be coming out in the relatively near future. There's probably a press conference going on somewhere else downstairs in the building as that's happening, but nobody's told me about it. Now, the procedure is set out in the code, and as I say, it's an administrative code. It provides how one can ask, what the target response time is, the form of the response, and then the second part of the code essentially deals with information which may be refused under 16 categories, which include defense and security, external affairs, law enforcement, damage to the environment, and so on. I don't suppose that includes the paper on which the answers might be provided. There is a review and complaints channel. There's first internal review by the bureau or the department concerned if the applicant for the information is not satisfied with that decision, and then, as I say, there can be a complaint to the ombudsman. Some people think that the system has been working reasonably well and that the requests that have been received have generally been complied with to general satisfaction. And so that's why I say I think it's important that we identify what are the drivers for change, and in that context it is helpful to look at what has led to changes in various other overseas jurisdictions on this topic before turning to the way in which they've sought to deal with that. Freedom of information generally, I think, is thought to provide a number of benefits to further, for example, the democratic participation and understanding of people in the government of their particular society. It is said that public awareness of the reasons behind decisions can improve support, can reduce misunderstandings, and can reduce dissatisfaction. Individual members of legislative bodies are said to be better able to conduct oversight if they have access to information, and generally confidence in government can be improved if decisions are transparent and if they are predictable. That confidence, it seems to me at least, is something which is a driver in many jurisdictions. Not the existence of confidence, usually the lack of confidence. Put more bluntly, often a lack of trust between various sections of society and government. And one sees echoes of that, I think, in the various calls that have been made in Hong Kong by various groups of people calling for this area of law to be reconsidered. Now, another benefit is the protection of others' rights, perhaps making governments even work better, making government bodies be alive to being subject to some scrutiny on the request for information, and of course possibly even redressing past harms. And looking around the world, one sees gradually over a number of years, but gaining generally, I think, impetus in the more recent 10 or 15 years, the adoption of freedom of information laws in different countries. In this region, Asia-Pacific region, it's perhaps been slightly more modest in its adoption. There's certainly a long history of it in Australia and New Zealand. South Korea and Thailand both adopted laws in the 90s. Japan has something from around about 2000. And I think that even individual areas of China have some freedom of information codes. Mainly, I think, introduces an anti-corruption measure, and that is obviously one of the features which it is said that such codes or laws might address. A big question is going to be, who are the bodies whose information should fall within the freedom of information on any given scheme? And if one looks around the world, you can see the different way in which those bodies are identified. Sometimes it's a list of bodies, a long list of what are said to be public bodies, some of whom you have to think about more than once to understand why they might be public bodies, and others where you think, well, why haven't those particular bodies been included? Other times, it is a very general description as to what is said to be a public body. Even public bodies may be specifically excluded, of course, for example, if it's felt that they handle very sensitive information. And then you have to decide what might be accessible, who can ask for it, how do you have to ask for it, what are the exemptions going to be, is there going to be some sort of process by way of an appeal, is someone going to provide some oversight, independent or otherwise? What are the sanctions going to be if there is non-compliance with the regime? And all those questions come up to play, including the knotty one, I think, of protecting whistleblowers. And that's, I think, something that any committee such as the one I chair is a topic that's going to have to be grappled with in some way. So I say the topic goes together with the question of records management, and the topic raises the tension in relation to matters of privacy. Looking at an article written in 2006 by a gentleman called David Banissar, under the heading of privacy, he said, as governments collect more and more personal information about their citizens and also adopt laws for freedom of information, conflicts have emerged in many countries between the right of access to information and the right of privacy. The two rights are frequently described as two sides of the same coin. It's perhaps more accurate to describe them rather as overlapping rights that are simultaneously complementary and conflicting. That's how I obviously try to be when I'm at home with my wife, both simultaneously complementary and conflicting. Now, any committee that's considering this and looking around the world at the other jurisdictions is likely, you might think, to engage in a comparative exercise as to what those other jurisdictions have, not just having identified the drivers in those particular places for any change to the access to information regime, but to look at the detail of what then is brought into play. And you will know that there are statutory schemes in a large number of countries, most obviously by way of comparison perhaps with a common law jurisdiction such as Hong Kong. One might look at the United Kingdom, the United States, Canada, Australia, New Zealand, all the countries that traditionally we look at when considering changes to our system, including changes potentially to the law. And each of those countries with their freedom of information regimes, all of those having a statutory regime, will therefore give rise to the fundamental question, should access to information be a legal right? And that is a question which is obviously one which the subcommittee will grapple with. What is the applicability or the scope of the access right? That's really the definition and how it's created as to the bodies whose information fall within the ability to gain access. Who might apply for the access? Is it, for example, only individuals? Is it only individuals who live in Hong Kong? Is it only individuals who are permanent residents of Hong Kong, or taxpayers, or only females? Whatever the nature of the description, it will be important, of course, to identify those who are eligible to apply for the information. Whatever the scheme, whether it's legislative or otherwise. What is the information that's covered? What is the form of the request? Can it be an oral request? In some countries, oral requests are not permitted. Others allow it. Can you make a request electronically, or does it have to be on paper? In Canada, for example, you're not allowed to make an electronic request. What are the forms of access? Do you get to go and look at the piece of paper, or are you given a summary of it? Are you given a photocopy of it? How does the access come to be provided? Do you have to pay for it? A very important question. Is the payment going to be a mandatory requirement? Again, in Canada it's mandatory, in most other jurisdictions it's not. What powers are there to refuse the request? What are the reasons for refusing a request? Do you have to provide those reasons if you refuse a request? What if the request is made to one department but really should be directed at another? Can the request be transferred, or do you just ignore it? Or do you write back and say, sorry, you're asking the wrong person, full stop? What are going to be the practical ramifications of that? And then, of course, vitally important, what sort of exemptions are there going to be? All of the systems, I think, all of the regimes around on freedom of information and of access have exemptions built in. Many of them are common one to another, some are not, and they're not necessarily all automatically ones to be followed or not followed if Hong Kong were to decide that a new freedom of access regime should come into play. What about public interest? Should that be overriding the right of access to information? If you're looking at exemptions, should there be different categories of exemptions? Should there be specific class-based exemptions? What about the concern about harm or prejudice, and in particular the giving of information which actually belongs to third parties, although it may have been collected by a government department? What rights might there be of those third parties, or what protections will be put in place for the information of those third parties? Time frame is to be found in most of the international regime. How quickly do you have to provide the information? Most are around about the 3-week mark. Some a little shorter, some a little longer. So these are questions that I think will arise on the provision by the government department. Then you have to think, what about by way of an appeal? What if you ask for something, you don't get it, or you don't get what you want, or in the form that you want it, can you appeal? Who's going to provide a review? And will there be a supporting service, for example, as an external or even some internal access to information officers? Will there be a commissioner of access to information if there is to be some scheme different from the present scheme? So I'm not suggesting that there are any particular answers yet to that question. Indeed, we have a number of meetings yet to hold for sure. But as the subcommittee moves forward, you can expect it to be addressing those sorts of questions with a view to making its ultimate recommendations in accordance with the terms of reference. So I say we're meeting roughly once a month. We would like to get on with it. A number of Law Reform Commission subcommittees take a while. I'm not criticising them for it, but we would like to be as quick as possible in the production of our recommendations on what is undoubtedly a relatively tricky topic. But that's probably all I need to say, and I think I've filled my time for saying it at this stage, but I would invite you to answer my questions now. I'd like to start by asking... No, all right, I'll let you ask some questions.
Thank you for a very informative and entertaining introduction. If you would like to ask a question or make your own personal comment on the topic, please raise your hand, wait for the microphone, and also maybe introduce yourself. Tell us who you are. And I can see a hand over there.
Want me to stay here or go to the...
Up to you.
Yeah, okay.
My name is Susan. I'm a solicitor by profession. I believe that this topic was first broached by the retired judge, Mr. Justice Wang, and also another district court judge, Trafi Land, also now retired. So I'm just wondering, this committee that you have been appointed rather frivolously while you are on top of a ski slope, how many members of your committee are stakeholders in this quest for information? Because it's obvious that it's not going to make much progress unless you get people who are really keen about this law being passed to be on that committee, of which you are now chairing, I believe. Is that right?
That's correct.
So are there any stakeholders? And if there are, could you name them?
Well,
or is it private?
No, that's not private. But in fact, I think the names of the committee have been published. Whether I can remember them all is quite a different point. But firstly, thank you for pointing out why Philan Chua is here. I thought she just liked listening to me speak. I didn't realize it was because she knows about the topic. I'm afraid the word stakeholder is one of my favorite non-words. It doesn't mean anything to me. If you mean who on the committee has an interest in seeing whether the law might be changed, then the answer to that is every member of the committee, and we've all been appointed specifically for that purpose within the terms of reference. If by stakeholders you mean who might be interested one way or not in the provision of access to information, again, I think it would be everybody on the committee. We're all taxpayers. We are all subject to government within Hong Kong. And as I said, we are a mixture of people. I think if a stakeholder means those who might have competing interests or potentially conflicting interests, then you have two senior members from the civil service. You have a gentleman who's a senior, I think, former president of the Hong Kong Journalists Association. You have academic lawyer, which is a professor at one of the universities, whose particular interest in media law. You have a member of the bar and a senior solicitor who is also a senior council member of the Law Society. And you have obviously the secretary to the subcommittee, who is a full-time staff member working for the Law Reform Commission. And then you have me, appointed as you say, frivolously, but I hope not entirely without... No, and I'm sure you didn't. I did, of course, because anybody who puts me in charge of anything is obviously not entirely sensible about their decision-making process. But the important point, I think, the committee has been carefully chosen to seek to ensure that anybody who might be properly regarded as a stakeholder, who might have an interest, will be represented. And it is very clear that you would expect members of subcommittees like this to be canvassing amongst their own constituency, if they have one, what views might be fed through to the subcommittee in its deliberation process. And that, I can assure you, is happening.
Hi, I'm Olivia Roseman from the South China Morning Post. I have two questions. I understand that you can't divulge the contents of the conversations you've been having so far, but you did mention this idea about the question of whether access to information should be a legal right. I'd be interested to hear your own personal opinion on that, if you'd be willing to share it. And secondly, you described the mission of the committee to, first of all, consider whether reform is needed, decide whether reform is needed, and then, if so, make recommendations, which doesn't really give a lot of hope for people that have been calling for this for a long time. It seems like a very long-winded process. My question is, should the recommendations that this needs to happen be made, how long is it going to take?
I'll deal with the first question first. Obviously, I'm a barrister, so I never have any personal opinions. I merely tell you what I'm told by other people to tell you. But if I were to have a personal opinion, it would probably be that if there is a good reason for changing the current situation, the current administrative regime, then it may not be the obvious answer to replace it with another administrative regime. And if one looks around the world, most countries appear to have adopted a legal structure based on statute for their freedom of information regimes. A number of countries think they've gone too far in it. I know if you read some of the materials relating to the Freedom of Information Act in the UK, I think the Prime Minister at the time thinks it was one of the biggest mistakes that his government ever made. I'm not saying that it was the only mistake his government ever made, but he does not think that necessarily it was the right thing to have done, at least not to the extent. One of the beauties of acting a little more slowly, as sometimes happens in Hong Kong, when we're talking about the change of law, is that we do have the benefit of looking around the world and looking at other jurisdictions and seeing what has worked and perhaps what hasn't worked, or what's given rise to unexpected consequences, which we are then able to take into account, which is, I hope, a neat segue to answer the second part of your question. The terms of reference are necessarily broad because they do not seek to tie the hands of the subcommittee in any way as to what recommendations it might make. But the process, I think, is one which is worthy of some time spent on it. I don't mean many, many years, but I do mean a reasonable amount of time in investigation, education, consideration, and then reporting. And I would think the real issue with most Law Reform Commission reports is not always the time that it takes to get to the report, but the time that there may be any activity on that report. Obviously, finding legislative time is difficult if a legislative answer is the right answer in this case. And there are a number of Law Reform Commission reports that have sat on the shelf for many years without activity on it. This topic is a relatively crunchy topic, and I think people realize that if there is to be a change, maybe it should come more quickly rather than some other topics, but it may depend on what else is going on at the relevant time. I would hope, as chairman of a subcommittee, that once I've put out a report, that somebody doesn't just put it on a shelf and leave it there to gather dust, but that they will take some action on it. And the important point from the wider public's point of view is to take part actively during the consultation period, which there will be before the final report is produced, because that is where people, with the benefit of the thinking of the subcommittee, can really add their own thoughts, put in their input. That's what you put in, isn't it? Input is what you put in into the whole process, so that we can consider for the final report what we think the best way forward of the options that will probably be identified.
Okay, next question from Terry and then Francis.
Hi, I'm Terry Nealon, a journalist. In a sense, you've already answered my question by pointing out that the government, for a number of reasons, has been slow to implement various recommendations of the Law Reform Commission over the years. But you seem to remain hopeful that something may emerge from your own subcommittee's tunnel. And given that this is a particularly contentious issue, is it not likely that nothing will be done?
Well, if I thought that was the case, I wouldn't be standing here, and I would at least have had the sense to say no at the top of that mountain. I am optimistic, and I like to proceed on the basis that I'm being asked to do a task which has been considered to be sufficiently important that a subcommittee be specifically set up in tandem with a sister committee on archives law. I think the two do go together, and ultimately the questions will probably have to be considered together. I think there is generally an awareness that Law Reform Commission reports cannot be allowed to just sit around after they've been produced. Somebody did suggest that there should be a subcommittee of the Law Reform Commission set up to inquire into whether or not there should be any changes to the Law Reform Commission and the government's of the day's approach to implementing their reports. But I am optimistic that when we come to a conclusion with the benefit of everybody's input, which will come through the consultation process, that it will identify of the various options that there might be borne in mind a way through which would be appropriate for Hong Kong and for the people of Hong Kong and for the government of Hong Kong, such that it is taken forward with some reasonable speed. Francis.
Francis Moriarty, RTHK. As you probably know, or may not, at least on this point, not only the Journalists Association took a position on this, but this club also took a position on this issue. And if it will be helpful, we can go back, I'm sure, somewhere and find that that report. The other thing I wanted us to say is that, as I know you do know, is that there actually was a piece of draft legislation that was produced in the 1990s at the behest of the very hard work of Christine Lowe, then a legislator, who put together a group of people. And that draft was written by Yash Gai from Hong Kong U. So I think that may be something that you might wish to look at. And thirdly, I will say that although they may be in another guise, there's quite a number of former reporters in this room today, in addition to the people still working in journalism. So the lawyers may dominate, but we're here watching you. As to the actual access to information and the drivers, I mean, one driver, of course, is always that it's simply the right thing to do. The other driver would be who are the users. And it's already been shown in Hong Kong that 90%, as was predicted by those of us who pushed for a law, 90% of the people who have actually come and asked for government information are business people. It is not journalists, it's not historians, it's not archivists, it's business people. So there's a real, if you're looking for drivers, I think the business community ought to be the biggest driver for access to information in Hong Kong. So I hope that's reflected. And my last point, in a way, is the professor or whoever it was you said is the person who's very interested in media law. A wild guess. Does that happen to be Professor Bacon-Shawn by any chance?
No, it's chap
Okay.
Andy.
Sorry?
Andy.
Okay, and okay. Yeah. Because one competing, as you pointed out, was the issue of privacy. And we have had a long history in this club in taking positions as journalists on privacy legislation and stalking. And these are two areas of which we're actively interested now again. And I think that you will find will be competing issues. So I don't know what your own view may be on stalking legislation, but if you have one, let us know, because that's extremely important to us.
Right. Okay, perhaps I'll just respond to one or two of those points. Obviously, you don't have to wait to the consultation period to put forward your views if you have any, and you speak from a position of some knowledge and interest. By all means, you just write to me if you want, or send me an email. Sometimes I read my emails, and until they go off the top of the screen unread, of course, then out of sight, out of mind, as most of the instructing solicitors in the audience would know. But send me things to look at, send me things to read, and I will feed them through to the committee, because I would like that information. As I said, I don't claim to be an expert in this area, at least not yet. I hope to be by the end of the process, but send me what you like. So far as privacy is concerned, I don't think I have a particular view on a stalking law, but I can certainly think about it and let you know. That's what I say to a judge when he asks me an awkward question as well. I'll think about it and I'll let you know. But the important message I think that I'm trying to get out is that we all recognize that this is a relatively difficult topic. But that doesn't mean that it's not a topic that needs to be grappled with. Probably the more difficult, the more it needs to be grappled with. And it can be done, and it can be done with reasonable speed. So I would hope that you can help me by providing me with whatever you think is useful at any stage of the process, and I will feed that through to the subcommittee. I don't know whether there's any other particular point that you wanted my comment on.
No, just basically that I think that this is an issue for which the journalists in Hong Kong, foreign and local, have been pushing for a very, very long time.
Yeah.
And the chief executive, the current one, said that he would sign a statement on press freedom and access, I think access to information, I think I'm correct in saying that, during his campaign.
Yes,
so
I think he did.
You may, in effect, be helping him to fulfill his pledge.
Well, anything I can do to help the chief executive obviously would be at the top of my list. Yes, there was one other point that jumped into my mind, but once you mentioned the chief executive, I'm afraid it jumped out of my mind again.
Right, we have time for probably 2 more questions. This gentleman over there, please.
Thank you. I'm King Wah from the University of Hong Kong Journalism Department, and thanks for letting me ask a question. I understand what I ask, you can't really get back to us a concrete question, as even though we have a lot of questions we want to know. But I just want to know, you mentioned about the ombudsman report that will come up, I guess, very soon. I just want to know, if you mentioned about the driver to change, if the ombudsman report suggests that there's a need to have a new legislation on the access to information, whether or not your committee will adopt this as one of the suggestions to put forward the proposal about a new law. And secondly, I just want to mention this is not the first time ombudsman issued a report. There's a second time. 3 years ago, there's a first ombudsman report, direct investigation into the access to information law. And in that, in the early report, the report suggests that there's a lot of problem in the existing system. One of the major issues is that the government really doesn't care about this. Most of the information officers did not have any knowledge about how to deal with all these kinds of requests. There's no internal training. They have no understanding how to, based on public interest, interpret the law. That's why they suggest there's a number of measures for the law. And this is the second time after 3 years. So I think this has some kinds of implication for your committee to consider. Thank you.
Yes, let me deal with the last point first. Obviously, one of the things that would be considered is the structure of any regime and making sure that it works, whatever it is. That's why I said the support services that you expect. Do you have information officers within the Bureau who are genuinely on top of what it is that they are dealing with? And I think that can be covered in various recommendations. So far as the Ombudsman's report is concerned, I'm not anticipating he will simply do all my job for me, but I am anticipating that he will cover a number of the areas which will be very important for me and the subcommittee to consider. And we will be reading his report with great interest, because it's bound to cover a lot of areas, a lot of topics in which we are interested and about which we are thinking. So far as whether it's the first or second attempt, I think it's important to bear this in mind. Since 1995, there has been an administrative scheme in process relating to access to information. Now, The report is obviously not out. We're still thinking about it. But looking at it externally, as you are, you might think that it's extremely unlikely that there would be what some would call a retrograde step in removing altogether any scheme for access to information. So what one is realistically likely to be considering is whether the scheme that's currently in place meets the demands for Hong Kong, and if not, what type of scheme and what features does that scheme have for its potential replacement. But we're not starting in Hong Kong from the position that there is no scheme at all relating to access to information. We do have a starting point which on its face provides information when people seek to access it.
Last question from the lady in front.
My name is Chloe Lai. I was the one who compiled the chapter at the Journalists Association report you just mentioned. You mentioned protection of whistleblowers. I'm not sure whether you can shed light on this, if it's included in the report or whether you have discussed it at the subcommittee, how that can be done. And then the other thing is, because a number of speakers have been talking about, we have been waiting for a long time, pushing on this law, and how long we have to wait for the subcommittee to release the report. Thank you.
Well, I thought eventually someone would ask me that direct question. It's unfortunate we didn't wrap up the lunchtime session before you had the chance to ask it. The answer, I'm afraid, is I can't tell you when we will be producing or when the Law Reform Commission will produce the final report. But I can assure you that I have other things I want to do in life, and that if I'm still doing this job in, say, a year or 18 months' time, I would be disappointed. But it is an important topic which is worthy of proper consideration and recommendations, and I'm conscious that a lot of people have been waiting for it. Other people have not. Other people don't mind at all the existing system, and we have to look at all of their views and take them into account. As far as whistleblowers are concerned, it's a natural topic to crop up in this area for consideration. Where one goes with it, I think it's just too early to say, and I'm not in a position to do that anyway. It's not a topic that I personally have looked at in any great depth yet.
I'm afraid this is all we've got time for. From the club, we have a little souvenir for you, Mr. Coleman.
Presents, I love presents.
Thank you very much.
Thank you very much.
An update when you're ready to.
Thank you very much for putting up with me.